All right. Good morning again, everyone. I'm Judge McBurney, for those of you who've not met me or vice versa. And I am out here in courtroom 8D to hear a TRO. That's all right.
Do I need this to be able to screen share?
Tell me your name.
I'm sorry, Your Honor. I'm Kyle Williams. I'm the attorney for the defendants.
I'm just trying to find your device. That's why I was going to mute it. It's gone. You do, if you have documents you want to share, and you're welcome to join the Zoom, you just need to mute it, and then there won't be this feedback.
Sorry about that.
Not a problem. Learning curve.
Hybrid is always interesting.
Yeah. Yep. All right. So I'm Judge McBurney. This is the case 2022 CV365315. It's, and I apologize if I mispronounce things. The company is Thomas Lavone, LLC, and then Mr. Wesley and Mr. Woodard, who are the co-owners of Thomas Lavone, versus Floshae at the Point and a Shea Embry. And we are here to work through a request for a TRO that plaintiffs have brought. First, I want to figure out who all we've got here in court and on our call. And then I'm going to give you my brief understanding, my limited understanding of where we are in the process, and then we can dive right into it. Let me just get a couple things written down here. All right. Good morning, Mr. Sterling. I think I see you on the screen there. You represent plaintiffs, is that correct?
Yes, Your Honor.
Great. Thanks for joining us.
Thank you, Judge.
And do you have anyone either in court or on the Zoom call that I ought to know about?
Yes, Your Honor. I have the plaintiffs, Mr. John Wesley and Mr. Thomas Woodard on the Zoom.
Okay, I see Mr. Wesley. Let's see if I can see Mr. Woodard. I see his tile, so he's around. Excellent. Okay. Thank you for being here. And on behalf of Floshae at the Point and Shea Embry.
Good morning, Your Honor. I'm Kyle Williams with the law firm of Williams Chusink. I'm here with my co-counsel, Joseph Rickman. And in the audience, if the court will allow the indulgence, Matthew Carter. He is a second-year law student working with us this summer. So he came down. He's probably the only one here who's excited. And then,
I'm excited.
And then we have my clients. This is a commercial real estate lease dispute. Floshae at the Point is the commercial landlord. The two members of that are Shea Embry, who's here, and Bob Flournoy is here as well.
Great.
And Ms. Embry was also sued in her individual capacity.
Okay. Excellent. So we've got everyone we need to have the conversation we're going to have. So here's my limited understanding, and I'm happy to have you all flesh this out during your presentation. Mr. Sterling's client entered into a 75-month lease. Never heard of one that's 75 months with Mr. Williams's client. They operate, I think it's a clothing store company at an address on Cascade. The lease has not yet expired, much to plaintiff's surprise. In late April, they got kicked out. They got 3 days notice. Somehow the police were involved. The allegations are, I'm just taking the allegations, not making any fact finding here, is that defendants removed all of plaintiff's property, their merchandise, et cetera, and are now trying to get someone else to occupy this store on Cascade. Plaintiffs contend they were current with the rent. and that thus this is it's conversion, it's theft, it's all sorts of things that were inconsistent with the contractual arrangement that existed between plaintiffs and defendants, i.e. the lease and any related documents. And we'll litigate some of that down the road. What is pressing now and why we're together now, because I don't think there's even an answer that's been filed. That's how early on we are, which is why it's a TRO, is that Mr. Sterling is seeking on behalf of his clients to get his clients back in the building so they can continue to run their business, keep defendants away from them, away from the property, and have defendants return to plaintiffs all of their assets so they can get back in business. And there are finer shades to it, and Mr. Sterling can flesh that out. But I think that's the essence of the dispute. Mr. Sterling, without getting into the nitty gritty, is there anything that got materially wrong there that you think, oh, Judge, you need to better understand what's going on here?
No, Your Honor, I think that's a fair overview.
Okay, Mr. Williams.
Your Honor, we take issue with the timeline as alleged and what notice was provided, how all of that occurred. But that is essentially the case forward down to a point.
Okay.
Did we comply with the lease in terms of terminating the lease and calling a default and retaking possession and rekeying, or did we breach the lease? Which
Got
are the
it.
merits of the case.
Okay. Well, Mr. Sterling, why don't you get started? It sounds like I'm coming at it with some basic information, and you all will refine that and expand it as need be. But I'm ready when you're ready.
All right, Judge, would you like me to sort of give an opening statement or just get right into the witnesses?
If you think an opening would provide more than what I've gleaned from looking at the pleading, meaning your complaint, because that's all there is right now, then you should do so. Otherwise, I'd hop into the witnesses.
Okay, all right. Well, Your Honor, at this time, I would call Mr. John Wesley, who is here present via Zoom.
Okay. I assume you all have discussed the fact that some witnesses may be appearing remotely. Mr. Williams did not jump out of his seat saying, wait a minute, I want Mr. Wesley here in court. You're all right for purposes of a TRO with a virtual appearance?
Yes, Your Honor.
Okay, great. Mr. Sterling, I'll let you swear your client in. I have a deputy here, but it's sort of like multiple screens removed. I'll have the deputy swear in anyone who's going to be testifying here in court. But if it's virtual, I'll let the attorney calling the witness do that.
Mr. Wesley, would you raise your right hand so the court can see? Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Would you state and spell your full name for the court?
Yes, my name is John Ray Wesley Jr. John, John, Ray, Ray, Wesley, Wesley, Jr.
And Mr. Wesley, how old are you?
I am 43.
And can you tell us where you currently reside?
I currently reside in Atlanta, Georgia, in the Southwest area.
And before that,
I'm sorry, Mr. You're kind of hard to hear, Mr. Wesley. You reside where?
I reside in Atlanta, in the Southwest area, Pasco area.
Okay.
And before that, where did you reside?
I lived in New Jersey for the past 12 years prior to coming here in 2020.
Can you tell us why you moved to Atlanta, Georgia from New Jersey in 2020?
Yes, I worked in New Jersey as a beauty executive. I this year celebrating 20 years as a beauty executive, largely in the fragrance industry. In 2020, I was planning to step away from my career to work exclusively entrepreneurially on our company, Thomas Lavone, which I co-own with my partner, Thomas Lavone Woodard. We had found a space in Southwest Atlanta after doing numerous pop-up shops all over the Northeast corridor of the United States, from New York, Washington, D.C., Philadelphia, and Atlanta. doing multiple pop-up shops and having success with that. Even a month of success in Macy's Atlanta, Lenox Square, where we did our first run of production. We found this space in Southwest Atlanta, which was not too far from where we had family that lived. And it seemed like an amazing opportunity for us to have a brick and mortar location within a community that we thought would be able to support our business.
And was the business location, the brick and mortar, was that at 2291 Cascade Road in Atlanta, Georgia?
That is correct.
And who is the company and landlord of that particular location?
That is Floshae at the Point LLC.
Okay. And did you enter into did you and your partner enter into your business partner enter into an agreement with Floshae at the Point and Shea Embry?
We did.
And can you tell me a little bit of just the basic terms of your lease agreement?
Yes. So we signed our lease in November of 2019. This was with the understanding that we were putting our house on the market in New Jersey to facilitate the move and the start of our business. We would finally close on the sale of our home around the first week of March of 2020. And then thereabout, 1 week later, we moved directly to Atlanta. The pandemic started the exact same time that we arrived in Atlanta. And we were in consistent communication with our landlord about our expectations to make good on our contract, to continue to move forward, and to get started on the redesign of the space, as it was a beauty shop. It would need to be converted to a fully functioning atelier. And so we worked very progressively on that throughout the pandemic without being able to have any income in order to make this come to pass.
And tell a little bit about what your business is so the court can understand exactly what you do.
Absolutely. So Thomas Lavone is a luxury niche women's wear brand. We are a size inclusive brand that boasts a very timeless feminine aesthetic that is supported by craftsmanship, meticulous attention to detail, and we boast an impeccable fit. That is supported by our CEO, designer Thomas Lavone Woodard, who has over 20 years experience as a technical designer, working for luxury brands such as Ralph Lauren, Jones New York, and several other private label brands. This brand not only creates ready to wear that is available online at point of sale, but we also are able to create bespoke pieces for celebrities and socialites, provided that there's the proper fit for it. So we do some run of production, and then we do some in-house production as well.
Now, do you all create and sort of use your own creativity to establish these pieces? Are you outsourcing? Tell me a little bit about how that works.
Everything is done in-house from start to finish. So Thomas creates his own looks from his sketches. He creates his own patterns to make those designs manifest. We source our fabrication from a number of sources. We do our own samples, our own grading. So that means that it goes from the sample size from 2 all the way up to a 14 to a 22. And that is all done in-house from his skill set. And then where we can, if we have select companies that we will work with to outsource some of our production, but leveraging our own patterns, our systems, and we provide all of our fabrication so that there's just cut and sew. And that just helps to streamline some of our production process because we do a lot in-house already, but this helps us to be a little bit more efficient when we're utilizing higher end fabric that we want to bring to market.
And are you commissioned or regularly commissioned? I know you mentioned earlier working with celebrities. Do you all get commissioned to do any specific pieces for celebrities or events or anything like that?
We have been very fortunate that we have been on a number of red carpets from 2017 up to the present. We have dressed celebrities such as Jamel Hill from ESPN, Kelly Carter, who from ESPN as well, Jamel Hill, I'm sorry, just a second, Terry J. Vaughn, who's a longtime client of ours, Essence Atkins, the list goes on and on. We've been on the Oscars red carpet, the Emmys red carpet. Our garments have been in the White House with during the last term of President Obama, with the last held there for all the Black journalists. Kelly Carter wore a design by us. So yes, we've been very fortunate to have had these types of moments as a two-person team.
Good. Well, let's go back. I want to sort of go back to the space, the brick and mortar at 2291. You said you all signed the lease in November of 2019.
Correct.
Now, did there come a time where you started to experience any issues with the space?
For the most part, we did not have many issues with the space up until this year.
And around what time this year?
Sure. There was late February. We received rain and we started to get some flooding coming through the weep holes of our space. Okay. We are at the lowest. I'm sorry.
Let me ask you a question. I'm sorry, I didn't mean to interrupt you. When that started to happen, did you share that information with your landlord?
Absolutely.
Did you take any videos?
Absolutely.
Can I show you one of those videos and you can tell me if you recognize it?
Yes.
Your Honor, may I show the witness? I know we're not in court, but may I show the witness what I'm going to call Exhibit A for the plaintiff?
Sure. How are you going to show it to the witness without me seeing it? And thus, it's basically been put into evidence. And it may be that Mr. Williams knows the video and he's not here to put up an evidentiary fight in that respect, as in rules of evidence. But either I need to put you and Mr. Wesley into a breakout room. I don't know that you can share a video in there or how you're proposing this, but otherwise you're playing it and everyone is watching it. So let me ask Mr. Williams, have you seen these videos before? Is this news to you? How do you want to try to navigate this? Your
Honor, if this is one of the exhibits that was provided to the court and us yesterday, we don't have an objection to that.
Okay.
And it is my understanding that included a number of videos, and I'm assuming that's what Mr. Sterling is referring to.
Mr. Sterling, I have a video in, Ms. Niles has set up two folders, plaintiff's exhibits and defense exhibits. And in plaintiff's exhibits, there is a video called flooding video. Is that the one you were going to play?
Yes, Your Honor.
Okay. And let me ask it a better question. Are any of the videos or exhibits that you're going to want to tender through Mr. Wesley or Mr. Lavone, if he testifies, outside the universe of exhibits that you shared with Mr. Williams?
No, Your Honor.
Okay, then I think we're going to be okay. Go ahead and play it, and we'll see what happens.
Thank you, Judge. Mr. Wesley, do you recognize that video?
I'm not able to see the video.
You were not able to see it?
No, I just see a file.
Oh, no.
Yeah, what we see on our screen, Mr. Sterling, is your file directory. When you did share screen, I'm going to stop your share screening for a minute. When you do it, there are two boxes to check in the lower left-hand corner: share sound and optimize for video clip. Make sure you check those two, and it ought to work better. If it doesn't, I can try playing it from here. I'm going to get out of sharing screen, and you can be back in there.
Thank you, Judge. I think I may have missed that part on the share screen. Let's see. Share optimize for video clip. There we go. Let's try this again. Can everyone see it now?
So I see Mr. Wesley, but your screen isn't sharing right now. I'll give you one more try and then I'll try it.
Okay, thank you, Judge. Let's see. Share sound. What about now? Let's see.
So we see your screen and it's the file directory, but there's no video play.
Okay. So if you could play it, Your Honor.
All right, why don't you stop sharing and I will give it a try.
Thank you, Judge.
Sure. Is it on your screen, Mr. Williams? Great.
She don't want to answer. I'm sending all videotapes to them. I'm done with this. This is a safety violation. The building is not good. The roof is pouring water into where the fires are at. And everybody wants me to be quiet and accept this. No, this is not acceptable for me. And then I got the threat her. She lost the bill with an answer me. She want to shut down when stuff don't go right. When you think you're going to get rent from us, we're not paying her nothing until she fixes this. She did nothing for us. We're not paying her nothing.
Mr. Wesley, did your footage capture that video? Can you tell us what we just witnessed?
Yes, so this was the day after another major rain. I think this was approximately April 6th. So on April 5th and 6th, there were 2 consecutive days of major rain in Atlanta. And this is exactly 1 week after we had alerted Miss Embry of flooding happening into the space. So during this week, I took video footage for those 2 consecutive days of what we were experiencing and where the flooding was coming from. This is at the same time, prior to this, we didn't have any flooding to this magnitude like this. We noticed a correlation at the time that there just maybe 2 doors down that Miss Embry had just dug up a water line for her new restaurant. And as the rain was happening, our end was continually getting flooded through the weep holes. And in fact, the adjoining space, the salon right next to us, was majorly flooded as well. So we just had to videotape this because we had brought this up to her and got no resolve.
And at the time, you said this happened in early April. At that time, were you fully current in your rent obligations?
So at the beginning of April, I was not current with March because I had brought up an issue to Miss Embry about an electrical box that she had installed. She had installed an electrical box, replaced an electrical box into our unit, and there was a water line running across the electrical box that her people had installed. And we asked for her to have it rectified. because if the water pipe bursted, that would cause an electrical fire, which would then be on our part. We were asking Ms. Embry to rectify this. She did not, and then the flooding happened. So we had two separate issues happening right here. The flooding was happening due to some infrastructural issues. We were addressing the electrical box, which is something that she had installed and could potentially be an injury to us if that water pipe, that's a plastic water pipe that was flowing from the HVAC directly onto the electrical box.
So, Mr. Wesley, had you withheld rent because you were unhappy about the electrical box situation, or you simply hadn't paid it because you were not able to pay rent?
No, I withheld it. I asked in an email to Ms. Embry and Mr. Flournoy, how did they want to handle this issue? Was this something that we needed to fix and we needed to take out of the rent, or was this something that they were going to fix? Ms. Embry then responded with a clause from our lease that said that after accepting the space, it was as is and therefore on the tenant. I knew that that wasn't correct because this was something that Ms. Embry had installed. So at this point, I started to seek legal counsel because we pay for Legal Shield. And I was seeking information on how we could receive some sort of remedy, because again, if that condensation pipe had bursted and water had come onto the electrical box, it would have been on our fault. It would have been our fault. At the time that I'm in correspondence with Legal Shield about this issue, we start getting the flood. So now we have a whole nother issue that we have to address outside of the electrical box that she installed. Now we have to deal in real time with flooding as she's pursuing the completion of her water pipe installment for her new restaurant.
So you had brought the electrical issue. When did you bring the electrical issue to her attention?
We brought that to her attention late February, early March.
Okay. But you were up to date in rent in February.
Correct.
Okay. And then when did you pay March's rent?
We paid March's rent on or about April 15th, because at this point, I'm still in talks with legal counsel about what our remedies are as we are dealing with the floods from April 5th and 6th. So I get the notion that I need to go ahead and pay my rent, although I have not gotten any word back from my landlord on how she's going to take care of the electrical issue, let alone the flooding issue that's happening in real time. So I paid the March rent on or about April 15th. I always have to walk them to Mr. Flournoy's address. That is my choice since it's right in the area. And immediately after dropping them in his flower pot each month, I send him a text message confirming that it is there. On this date, after I send the text, he does not respond, which every time prior, he responds, or he comes out and greets me. On this time, he does not. I noticed that it was unusual. And then 2 weeks later, I pay my April rent and I do the exact same thing. I send a text message alerting that the rent is in the pot. Please confirm receipt. He does not respond. So then I send an email with both of them on copy, alerting them that I have paid both rent. Please confirm receipt. I then get a response back that says, John, we received your partial rent payment, but your lease has been terminated. This is in the same month that they've received two payments.
When did you first receive the notification that there was an intention to terminate your lease?
This is the week that I made the second payment. So this would have been around April 25th.
Okay. And you made the March payment in April the 15th.
Correct.
And when did you make
about April 15th?
And when did you make the April payment?
It was on April 26th or April 25th. It was that week. It was the exact, as a matter of fact, the same day that I got the email that said my lease was terminated, I had already just dropped off the rent. I did not even know that I had just received this email because my intention that day was just to turn in my rent. When I got home that evening, I saw an email that said my lease had been terminated because I had already, and I sent an email saying that please confirm that you received the rent.
And was this after you had brought the attention of the electrical issue and flooding issue to Miss Embry's attention?
Correct.
And had you communicated with her at all about the fact that you might withhold rent for a period of time until she resolved those issues?
Well, in my initial email about the discussion of the electrical box, I asked, how do they want to handle this? Should we, be prorated the rent for the cost of rectifying XYZ issues or exactly what? And her response was that copy from the lease that says that it's as is, it's a tenant issue. But again, I knew that this was infrastructure, so that couldn't just be a tenant issue.
Okay. How long between the date you got the letter saying your lease was terminated and the date in which you were essentially illegally evicted?
Objection, Your Honor.
So I don't know if is your microphone on? I'll make sure, is the green light on? Is it on now? Great, now they'll be able to hear you. So, Mr. Sterling, there was an objection to your argumentative question. You don't need to conclude that it was an illegal eviction or not. That's for future litigation, but I certainly can refer to it as an eviction.
Why don't you tell the court what happened between the date you got, tell me, what date did you get the letter about your lease being terminated?
So I believe that was on that Wednesday, which is the day that I would have turned in my rent payment.
And who did the letter come from?
The letter, there was an attachment from the law office of Toussaint, if I'm pronouncing it correctly, Williams Toussaint. That was, it said that there was a notice of default, is what I remember, and a termination of lease, is if I remember the correct legal term. And that was from the attorney's office. This is what she utilized as a formal termination of our lease.
Was that accompanied by a court order?
No.
Okay. Was there any affidavit of dispossessory that was provided to you in addition to that letter from the attorney?
No.
And tell me how many days between, tell me what happens next. What happens after you receive this lease termination? What's the next step? What happens?
So on Friday, I am working from home.
Do you remember the date?
Yeah, I believe it's April 28th, if I'm not mistaken. April 28th is, I believe, it's the Friday. And
so April 28th, just take judicial notice. April 28th is a Thursday. So are you talking about that Friday or Thursday?
Okay, so it's the 29th. Yeah, so it's definitely Friday. So it's the 29th.
Okay.
It's definitely Friday. So April 29th, that Friday, Thomas is working at the atelier. I am working from home because it's a slower day. He's working on finishing up some items that we're getting ready to bring to market. And he has his assistant there. And I get a phone call from him that Shay has entered the space with a police officer and a third party, and they are trying to evict him. So I run down in real time, and as I come to the space, there I see Jay Embry, an unidentified police officer, and a third unidentified black male.
Now, was it the, I'm sorry, was it the police? Was it the City of Atlanta Police Department, or was it the sheriff's office?
No, it was City of Atlanta.
Okay. I'm sorry, you can continue. What happens next?
So as I come in to explaining to the police officer that what Ms. Embry is trying to conduct is not legal. We have not been served anything from Fulton County. Our rents are up to date, and that we can show exactly what seems to be an issue from her perspective of why she's trying to retaliate against us and have us pushed out. So we show the electrical box that clearly has a condensation pipe running across it. We still have in real time evidence of where the flooding had come because there's still debris and mud around, and the mud around the base is still wet. He's completely unattentive to us. He is not wearing a badge. And we don't know who this third male is and why he is present, but he is off in the background taunting Thomas with the police officer and Miss Embry present. I continue to try to share with the police officer this. There was no protocol for this. There's nothing filed with Fulton County. We are confused as to why this is happening and why is he there and why do we not know his badge number? Why hasn't he identified himself? And how did they even come into the space? Because our space was locked. We weren't open for the day. So there were so many questions and there was no way for us to really fully respond and protect ourselves. The only thing that we could do was remove our space because we were being intimidated out of the space. He told us we had to go, that this was her building, and y'all just work that out in court, is what he told us.
And
so,
did the police officer or any of the other individuals present, Miss Embry or the police officer, did they have a court order from Fulton County?
No, they did not. And in fact, we called the police, we called 911, and we had additional officers to come on site. Senior officer, Officer Civilian, if I was saying his name correctly, called this police officer back to the scene because he had left the scene. And they admonished him and told him that the Atlanta police is not utilized for eviction. And where he refused to identify himself prior, we now had to have, we had video footage of him identifying himself and giving us his badge number so that we could get a clear, full story as to why he was being utilized to help execute this illegal eviction on us, especially since this is clearly not their jurisdiction. He states that he was hired by Miss Embry. We had to file a police report. The police, the senior police officer, I think Officer Civilian, that the space had to be opened back up for us to retrieve our items. It never was. And that was how the end of Friday went.
Now, tell me, what items did you all have in there at that time?
All of our merchandise, all of our fabrication, all of our patterns, our sewing machines, pieces that were being worked upon in real time for clients, artwork that we had personally customized for our space, all of our fixturing, everything that you would want to have a proper atelier, everything that we needed to run our business was still there on Friday.
And where are those items at now?
I cannot tell you. Everything is no longer there.
Do you know where those items are at all?
I cannot tell you, but what I can tell you is that on we received an alert through ET that our space could have been burglarized Thomas shows up in real time, and there he sees Ms. Embry, Mr. Flournoy, one of their employees from Aretha's restaurant, and a fourth unidentified Black female, one of Ms. Embry's construction workers, and they're all in our space, bagging up our merchandise, bagging up our things, and the police show up and they go inside our space with Miss Embry and everyone present. They lock the door and they talk to her. But they were responding to a phone call about a break-in into our space, right? Because we, from Friday, turned our security system back on so that in case something else was to happen, that we could have footage of it. So on that Monday, while the break-in is happening, because that's how we have to term it, I call 911 and I ask to be connected to the Fulton County Sheriff, and I tell them that there's an illegal eviction happening in real time because now Miss Embry is trying to continue what she did from Friday now onto Monday. I run there on site and 3 additional police officers show up. All of the police officers go inside of our space with Miss Embry. And again, they're watching Miss Embry and her associates bag up our merchandise and things. We are left outside and Miss Embry presents to them the document that she presented to us as proof of an eviction. The police officers allow them to continue, and then they come out and
I'm sorry.
I'm sorry.
What was that document, Mr. Wesley? Was that a court order?
No.
What was it?
It was the document from her attorney's office about a termination of lease or a notice of default.
Okay. And can you just explain to the court sort of what the daily consequences are of you not having access to all of the stuff? I'm not trying to downplay what you all create, but all of the items that were taken from you, what is, and you're sort of, you being evicted, what have been the consequences, the daily consequences as a result of this?
So there's numerous side effects to this. This is over 20 years of fashion history that gets erased, right? So each pattern that is created by Thomas Lavone is personalized by Thomas Lavone. It is the direct manifestation of the creativity that lies within his head and is manifested in a garment from start to finish. That's over 20 years of history that dates back from the time that he was in undergraduate school. That is a wealth of information that is the basis of our whole DNA of a brand. So we're not just talking about merchandise and fabrics and garments, but we're talking about a brand's history. We're talking about the trajectory of our future career, our fabrication that we have for collections to come. We're talking about expensive fabrications that we've outsourced from other countries. We're talking about very specific sewing machines that have to be utilized in order to create the designs that we bring to market. There's so much to this that was just taken from us in a blink of an eye for what reason we cannot understand, and we can't put or make any sense of it.
And what about the missed opportunities? Or have you all had I know you said earlier you designed for celebrities. Are you missing opportunities as a result of what occurred?
So yeah, so very, very succinctly, we had just completed production on our spring summer collection, literally, and it was literally on the wall there for us to be able to take advantage of the launch of our spring summer collection in chiffon. So this is thousands of dollars of merchandise that we had just had produced locally here out of Atlanta, where you traditionally would have our merchandise when we outsource and have it produced. We typically would go to New York. but this was going to be an opportunity for us to brag about what we had done here in Atlanta organically by working with a very curated manufacturer, the level of work that we had literally had this work just produced. It was on the floor to be sold at the start of the week. We're talking about April 28th, 29th. We're 1 week away from Mother's Day. So key selling time, all of that was gone. In addition to that, there were over 60 garments that were just produced in-house that were a part of our lower tier of garments. So more price point, more, I would say, mass market price point, right? So a much more price sensitive piece that would have helped to generate more sales for the traditional customer that lives in that neighborhood who may not have the residual income to afford a piece in chiffon. They might be able to afford a piece in ITY. Well, all that had just been produced in-house. That's about 60 pieces. So all of that had been taken. And again, in all of our future fabrications for gifts that we were planning to do, it's hard to put it into context or to even wrap my head around it in to give you a full perspective. It just it's heartbreaking.
How do you calculate what it means for your business when you're not able to, fulfill an order for a celebrity to walk the red carpet? How do you calculate that?
Monetarily, we can look at what the potential losses are. What you cannot put a value on is someone's life's work. This is what Thomas does. This is how he eats, lives, breathes. It's fashion, it's design. This is what he gets up every morning to do. And when you take away everything that he has built, all of his tools that he utilizes in order to do his job, and I to support this job, you not only cripple us, we have to start from zero as if we never existed, right? So we had a website that's up and running where we're selling merchandise that now we have to shut down. Social media, thousands of dollars that we spent in marketing directly in this community within this said business district that we had invested in our fashion shoots and things of that nature to market to the community, that now all of that is not. Like we can't even utilize these images because we don't have the merchandise now to sell. We don't even have the fabrication to go back and reproduce it. So it bounds our hands.
No further questions, Your Honor. I would tender the witness.
Mr. Williams, do you have any questions for Mr. Wesley?
Yes, Your Honor, very briefly.
When you're ready.
And in this new world, I'm not comfortable sitting down, but I feel like I need to sit down.
You don't need to if you're near a microphone with a green light on it. Okay. So if you want to be up at the podium, you can do it there. You can do it right where you are.
I want to be disrespectful to the court.
Don't worry about me. I am focused on people being able to see and hear each other. And Mr. Wesley will be best able to hear you if your mouth is, but you can be standing at the podium and there's a microphone higher up. So either of those works for me. I'm not feeling disrespected by anyone in this litigation so far.
Thank you, Your Honor. I'm still, I was raised one way. Mr. Wesley, I'm Kyle Williams. I'm the attorney for your commercial landlord and Miss Embry. Can you hear me and see me?
I can hear you. I can't see you.
Well, let me do this. I'm going to add you to the spotlight. Now you guys are side by side on the screen.
Here we go. Mr. Wesley, I'm going to show you what we have previously circulated to the court and your attorney, Defendant's Exhibit Number 1. Your Honor, if I can screen share.
You should be able to. Go for it.
Mr. Wesley, can you see on your screen a lease summary?
I can.
And do you recognize this document?
It looks familiar.
And this is your lease, correct?
Correct.
And you signed this lease along with your business partner, correct?
Correct.
You negotiated this lease, you were familiar with it?
Correct.
Going to point out just a few sections quickly. Section 1.1, you were obligated to pay your rent first of the month, correct?
Correct.
You were also obligated under 2.4 to pay operating expenses and common area maintenance.
Correct.
And under section 2.5, it was your responsibility for utilities, including this electrical box you've referenced a few times. Correct?
Could you repeat the question? You've gone in and out.
Yeah, so let me ask you a question, Mr. Wesley. Do you have multiple speakers playing in your room? I get bad feedback from you, like there are two people in your room.
No, I only have on earphones.
My audio is not on.
Yeah. Mr. Wesley, I'm going to ask you to mute yourself until you're talking. Let's try that again. Look at that, no feedback. So why don't you ask your question again, Mr. Wesley? When you're answering, unmute, and then please mute again. The feedback we're getting is coming from your connection.
Mr. Wesley, you see on the screen section 2.5, which is entitled Utility Charges. You were responsible for all utilities and the maintenance of all utilities, correct?
No.
You don't see that in your lease?
We do not pay water.
Okay, but electrical, you were responsible for the provision of utilities into that space, correct?
I am responsible for electrical services. Yes.
So section 3.1, and you referenced this because you said Ms. Emery responded to your complaints about the electrical box, that you had accepted the premise as is, where is. Do you see in section 3.1 that you did accept the premise as is, where is, and that landlord is not obligated to make any improvements?
I do see that.
So I have a question for you, Mr. Williams. That's what I thought Mr. Wesley said, that we accepted it as is, where is. Partway through the lease, this electrical box appears in a place that brought concern to Mr. Wesley and Mr. Lavone because there's a condensation pipe or something. So, and maybe you're going there.
I'll get there.
But what I see this lease saying in 3.1 is exactly what Mr. Wesley said, which is we take it as is.
Correct.
But then allegedly your client changed something with it, and the as is situation is not as is anymore. It's changed, and there's this concern about water and electricity being bad friends.
Your Honor, if you'll give me just a few minutes, I would get there and
You're getting there.
close
Okay.
that gap as quickly as I can. I apologize for that.
No. I just want to make sure I wasn't following where you were going, but you're telling me you're not there
Sometimes
yet.
I don't either, Your Honor.
Okay.
Section 8.1. You complained about flooding, and we saw the video. That was from a storm event. That was from rain, correct?
The effects of rain.
A pipe didn't bust or anything like that inside of the space. It was flooding from the outside in, correct?
I can't tell you what caused the flooding.
And under section 8.1, you notice that the landlord is not responsible for a casualty such as a rain event or flooding event.
I see that.
So section 10.1, you knew that if you did not timely pay your rent on the first of the month, that would be a default of the lease, correct?
No. In our history, Ms. Embry and Mr. Flournoy have traditionally, throughout the entire time of our lease, accepted rents well after the first.
But under the specific terms of the lease, you do acknowledge that it required you to pay rent on the first of the month, correct?
I acknowledge.
I'm sorry, Mr. Wesley. And that if you didn't timely pay rent or the late fee that associated with late payments, that would be a default, correct?
I acknowledge.
And below that, section 10.2 says what the landlord can do if there is a default. And you've talked a lot today about this illegal eviction. And your attorney has pointed out repeatedly that there was not a court order, which we stipulate. But under section 10.2 of the lease that you signed, negotiated, and entered into freely, it gave the landlord the right to self-help, correct? The landlord could retake possession without notice to you. The landlord could re-enter the space, rekey the space, and remove you as the tenant and your possessions from the space upon an event of default, correct?
Fraudulent clauses in leases are not executable within the state of Georgia, and self-help within the state of Georgia is not legal.
What was the first word you used in what you just said?
Self-help in the state of Georgia is not legal.
Okay, I thought you said something else. Fraudulent? Did you say fraudulent clauses?
Illegal clauses in leases do not trump Georgia law.
Okay. Well, we'll let Mr. Sterling take that up, but I appreciate that perspective.
Thank you, Mr. Wesley. And moving very quickly to close the circle for you, Your Honor, I'm going to show you, Mr. Wesley, what has been marked as Defendant's Exhibit 2. It has previously been shared with the court and Mr. Sterling. Mr. Wesley, you indicated that you had your attorney, you engaged an attorney through Legal Shield. I'm showing you an email that I represent is dated March 22nd from an attorney, Terrace Burrows. Was Mr. Burrows your attorney at that time?
Mr. Wesley, you're on mute.
It is correct. At that time, we were consulting with Mr. Burrows.
And did you instruct him to send this notice of plumbing issues, plumbing not being up to code, electrical issues within the unit, flooding?
That is correct.
So that's March 22nd. The second page, or the third page of that, because the first page is just a continuation of that. It's an email from me, March 30th, to Mr. Burrows, notifying him that I represented the landlord, that we had received your email or his email complaining, and we needed more information because you had not previously, prior to that, complained about plumbing or electrical issues or flooding. And we were not aware of any such, as you testified earlier, correct?
Correct.
Did Mr. Burrows discuss this email with you and obtain additional information and provide that to either your landlord or to your landlord's counsel?
I cannot verify that.
Why not?
We discontinued conversation with Mr. Burrows around the end of March. And on March 31st is when we got another flood. That's when we got our big flood. And then
When
the
did
week prior was April 5th and 6th, which is the video footage that you just saw.
Did you ever communicate to either landlord or have Mr. Burrows communicate to me that he was no longer your attorney?
So at the time, we did not commit to Mr. Burrows as our attorney. We were seeking legal counsel, and we were seeking what our options were with Mr. Burrows. We did not officially have Mr. Burrows as our attorney. And so at this point of communication, we've decided to move forward away from Mr. Burrows because we didn't feel that we were going to be serviced well.
And it's around this time, Mr. Wesley, that you stated in your earlier testimony that you started withholding rent, correct?
I had already withheld. We're at the end of March. So March was already withheld because we had not gotten a clear answer of how to get the electrical box rectified.
You in fact did not pay March rent, correct?
I did withhold March rent.
And previously you were late paying February rent,
February was paid.
but it was late, correct?
No, it was not late.
And you did not pay a late fee, correct?
I did not pay a late fee.
And January was also late, correct?
January was not late.
And you did not pay a late fee in January either.
I did not pay a late fee in January.
I'm going to show you what we've marked as Defendant's Exhibit 3. It's a correspondence from my law firm dated April 11th, entitled Notice of Default, directed to Mr. Burrows, who everybody understood, at least on our side of the table, that was still acting as your attorney. Have you seen this? Did Mr. Burrows disclose this letter to you, discuss it with you, and how to respond?
You need to unmute Mr. Wesley.
Excuse me. Again, at this date, April 11th, Mr. Burrows was not representing us. We were still seeking additional legal counsel.
You do see in this correspondence that I raised repeated voicemails and emails to Mr. Burrows, that we've not heard anything back with respect to any electrical or plumbing issues, that the landlord would abide clearly by the terms of the lease, including repair, replacement, and maintenance if owed under the lease.
I see that.
But that regardless of those issues, you were still obligated to pay rent. And that you had failed to pay rent in March and April, you were deficient in January and February. And as of April 11th, you owed the landlord $5,000, $5,080.24. Is that correct?
That is not correct.
You did not owe the landlord?
Well, Mr. Wesley has already told you he didn't think he was late in January and February. And so if that figure includes late fees, he's disagreeing with those.
We're stipulating to that, Your Honor. We
Okay.
understand that. Did either you or Mr. Burrows respond to this notice of default?
I cannot speak to what Mr. Burrows would have responded to. I can tell you I did not respond.
And you see in this second full paragraph on page 2, and you reference this, that historically the landlord had worked with you on late payments. The landlord was putting you on notice that it was not going to waive strict compliance of the lease. Going forward, the lease needed to be complied with. You see in the last paragraph, Mr. Wesley, where despite any obligation under the lease to do so, landlord agreed to give you time and an opportunity to cure the default, or if it wasn't cured, the lease would terminate and the landlord would exercise the self-help remedies available to it under the lease. You see that?
Could you specify the number of days that it says that it is available for the balance to have been rectified according to this section? Because I can't see it.
It's a seven, this is 7 days.
This is 7 days.
Oh, well, in that case, they had already received a payment by April 15th and the following payment by the end of the same month that those rents were due.
But those were not
been
full
well within
payments.
that. Again, sir, we're going according to precedent and history. I had not paid a late fee for January or February. March was paid by April 15th. Your letter, according to your own testimony, is dated April the 11th. They received a payment on April 15th. We're in the same month where April is due and it is paid in that month. So the question then belies to your client. Why would she execute an illegal eviction? I defer to you.
So you admit you did not pay late fees and that you tendered April late. You tendered March late. And you were on notice that the landlord would not waive strict compliance with the lease, correct?
According to the date of this document, April 11th, those are the stipulations that you just stated. And according to that date, they received a payment by April 15th in line with this 7-day notice.
And those payments were returned to you, correct?
No,
Those payments were not returned to you?
so I will specify for the court, there was a payment that for both payments that were made that month. We noticed that in May, after this eviction was executed, your client or someone representing your client placed one of our payments in the mailbox of the commercial address of our space, 2291 Cascade Road. It was never gone through the Postal Service. It never made it to our home address because they did not have our home address. So your client simply put the payment that we gave them into the mailbox of the commercial address.
So they returned the payments.
They put the payment in the commercial address box. They never returned it. It did not go through Postal Service.
Well, I'm confused, Mr. Wesley, whether a mailman puts it in your mailbox or someone else. I don't know how you'd know who put it in there, but maybe it just wasn't postmarked. But why does it matter who put it in your mailbox as long as it's in your mailbox? Why is it not a return?
Because, Your Honor, again, this is...
Your Honor, if
I can ask him a question, Mr. Sterling. He can answer my question.
Oh, okay.
It can flow that way.
So, Your Honor, I have no problem with answering the question, and I want to put this in context. This payment being remailed to us in question happened directly after the offenses. So it was never before the police were utilized to evict us. This was damage control that would happen sometime in late May, because again, we still have to check our mailbox periodically, even though we are not in business. We still have bills, so we still have utilities that we're receiving bills for. This is how we discover how they decide to return, and I'm using in quotation marks, a payment.
Okay, I follow you. Mr. Williams, anything else for Mr. Wesley?
Finally, Mr. Wesley, wrapping this up, showing you Defendant's Exhibit 4. Correspondence from our firm dated April 21st. Providing notice of the termination of lease. and despite any obligation under the lease to provide you with notice or an opportunity to remove or surrender the premise, this correspondence again gives you 3 days notice to collect your stuff and move them out, correct?
According to this notice.
Did you ever see this correspondence from Mr. Burrows, your attorney at the time?
Sir, I stated that Mr. Burrows was not our attorney at this time. So there was no correspondence with Mr. Burrows.
There was no correspondence between you and Mr. Burrows during any of this time?
Not in April. I shared with you earlier that as before late March, that we had ceased a representation relationship with Mr. Burrows. We never had a formal representation relationship with Mr. Burrows. We only sought him for legal counsel. And we ended that in March. There was no representation from late March through April. All the dates that you are acknowledging, they were not representing us.
But at some point during this time, you were having direct email and text correspondence with my clients, with Ms. Embry, correct? And she was
At this time,
reiterating.
I had no longer corresponded.
And she was reiterating the termination of the lease, the default of the lease, and again, providing repeated opportunities for you to remove your stuff from the space, correct?
Let's be specific. What date are you specifying?
During this time period at the end of April.
That I would be in specifically April. Are we talking about correspondence with Ms. Embry?
Yes.
So again, my correspondence with Ms. Embry was in regards to the acknowledgement of payments of rent on April 15th and April 25th. Those are the only times that I initiated conversations with Ms. Embry or Mr. Flournoy. It's with the acknowledgement of March and full rent.
So the question is different. It's not what did you initiate? The question, Mr. Wesley, is did you receive any communication, email, text, phone call, letter from Ms. Embry indicating that you had some time to get your inventory out of the premises, but that the lease had been terminated?
Yes, I did the same date that I left the April payment. I believe that would have been around April 25th or 26th is when I received that communication that the lease was terminated and that I had 3 days to move. And in context, Your Honor, I had just again made 2 payments. So 2 weeks prior to this, I'd already brought the March payment up to in arrears, brought it out of arrears, and I had just paid my April rent and brought it out of arrears. And I received this email.
What did you do in response to that email? Did you communicate in any way with Ms. Embry or anyone associated with her?
I did not. At this time, I was mobilizing with my person. I was trying to get help from the 2 council members who represent this district, who had very intimate ties with Ms. Embry and who understood the level of work that this development was supposed to rise to. Your Honor, I want to put into context, this was not isolated. These issues were not isolated to us. Prior to the execution of this illegal eviction, I had sought a meeting with the 2 council members who represent this district to discuss the infrastructural issues that many of the tenants there face, and that we were, one, clearly declined our invitation to meet, citing legal issues sharing with me that she had talked to Miss Embry.
All right, so I don't want you to get into hearsay here. Stop. My question was very narrow, and I think you've answered it. You got word from Ms. Embry that the lease was terminated and you had 3 days to remove your inventory, product, et cetera. And instead of responding to that, which you're saying you never did, you reached out to city council people, you were marshaling resources, whatever your phrase was. But what you did not do is reach out to Ms. Embry or any of her representatives to say, wait a minute, I just paid April. Is this being terminated? I need more than 3 days. There was no communication from you to them. Is that correct?
Oh, yes. So I did respond in an email that this was illegal, that we had not been served a dispossessory affidavit, nor had we been served from Fulton County Sheriff. And that was my response, an email to what they sent.
Okay.
I didn't believe that I would be evicted because I knew that legally that what was being shared with me, the grounds that the legal process had not taken place because I had received their acknowledgement of my rent.
Okay, thank you.
So that's how I responded in email.
And Your Honor, just for the court's reference, the email that he is referencing, I'm not going to bring it back up. We've belated this enough. It is included in Defendant's Exhibit 2 as page 9, where that was his one and only response.
Okay. Do you have any other questions for Mr. Wesley?
Mr. Wesley, in today's hearing, this is a TRO hearing, and we've talked a lot about the underlying merits of this commercial lease dispute, but you're asking, if I can boil this down and hear from you, you're asking for two things. One, to be put back into the premises for you and your business to be able to go back into the space and put back in there, correct?
That is correct.
Because you're no longer in the space. The action that you contend is an illegal eviction has already occurred.
Right.
And if I can boil it down, the second thing that you're asking for is for the return of items that you claim that my client took from that space, but that action as well has already occurred. Correct?
Correct.
No further questions, Your Honor.
All right, Mr. Sterling, Mr. Sterling, do you have any redirect of your client? You're on mute.
Just briefly, Your Honor.
Sure.
Mr. Wesley, between November of 2019, when you first signed the lease, and March of 2022, did it ever rain?
Yes.
And did the property ever flood before the first event in March of 2022? And you didn't experience an issue with the water flooding the property until I think you said that there was some digging happening next door to your premises.
That is correct.
And those letters that were sent to Mr. Burrow, the attorney, he was not representing you, and you did not have an opportunity to look at those letters.
That is correct.
So the items that Mr. Williams just discussed in those letters with the 7 days and all of that, you were paying the rent, even though you hadn't seen that expectation in those letters.
Correct.
No further questions, Your Honor.
All right. Thank you, Mr. Wesley. Mr. Sterling, we are an hour and 20 minutes into our 2-hour window that we've got. I want to make sure Mr. Williams has a chance to put on evidence if he wants to do that. Did you have other witnesses you were going to call, or have you covered what you need to cover?
Just Mr. Woodard, Your Honor, and I'm not going to go back through everything, but I do want him to talk about sort of what has occurred, because he's the creative mind behind this. So I wanted to talk about the damages that he's experienced just a little bit, Your Honor. It won't take me more than 10 minutes or so.
You don't have 10 minutes right now. What I'm going to do is see who Mr. Williams is going to call and see if we can fit that in. And then if necessary, I'll hear from Mr. Woodard. But Mr. Wesley gave, I think, eloquent voice to how this isn't simply, hey, we need our inventory back, but lost opportunities and the creativity that infuses all this and whatnot. So if there's time, I'll hear from Mr. Woodard, but I don't feel like I am uninformed about not just the financial impact this has had, but the professional impact this has had on your clients. Who are you planning on calling, Mr. Williams?
Your Honor, we do have our two members here, but I feel like the court understands what's going on. We've got the facts. We are not going to call a witness and just proceed to argument.
Okay, then why don't we have Mr. Woodard? Hopefully his connection is a little different than Mr. Wesley's because it got kind of complicated there. But I'll pivot back to you, Mr. Sterling. If you want to call Mr. Woodard, we can do that.
Yes, Your Honor. I just briefly, Judge. I know you've got the sense of what happens, but I think it will inform the court just to hear from him briefly.
Okay. There he is.
Mr. Woodard, would you raise your right hand so the court can see? Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I think you're on mute. I can't hear you.
So, Mr. Woodard, why don't you say a few things? Spell your name for me. All right. We're not getting any volume from you. It doesn't show that you're on mute. The system says that you're on, but there's no audio feed coming from you.
Well, I guess in this new age of technology, Judge, we may have to just proceed to argument. But I know you understand, Your Honor, and I'm confident that Mr. Wesley did a good job of explaining it, and I'll try to explain it in argument as well.
Okay. Well, why don't you get started?
Thank you, Judge. Judge, as Your Honor knows, we're here on TRO or other equitable relief that is needed for Thomas Lavone LLC, Mr. Woodard and John Wesley. Judge, the elements of a TRO, as Your Honor well knows, is there's a substantial threat that the moving party will suffer irreparable injury if the injunction or TRO is not granted. I believe we've demonstrated that, Your Honor. There is no way for a company such as my clients in their unique fashion design business to get back the goodwill they lose every day. Every time a client calls and they can't fulfill an order.
So let me pause you there, because I agree with you. And it was, like I said, it was helpful to hear Mr. Wesley's rendition of what Mr. Woodard would have said. Why is the solution of the TRO not simply, hey, give the plaintiffs their product back? Why does it need to include put them back in a place that seems to have brought them great grief and distress over the last few months? There may well be litigation going forward about how there was a wrongful eviction and lost profits, et cetera, and expenses. But to me, the heartbeat of this creative enterprise is partly inside Mr. Woodard, but it's his sketches and his materials and whatnot. So I don't mean to short circuit things, but I'm inclined to say you better give them their stuff back. But giving your clients also this space back seems much more complicated and maybe a steeper hill for you to climb. So tell me why an immediate return of everything that was in 2291 to your clients is not enough.
Well, Your Honor, part of it is that that space was the only space they had, as Mr. Wesley pointed out. It was the only brick and mortar location they had where their clients were aware that they were located, where their clients could come visit, where they actually had the appropriate amount of space to do the necessary work and creativity to provide what they were providing for their client base, sort of being booted out. And, you know, if Your Honor wants to hear me on this, there's no self-help eviction under Georgia law, as Your Honor well knows. There is no eviction without a court order. And so Ms. Embry, aided and abetted by her attorney, essentially did effectuate under Georgia law an illegal eviction. She illegally changed the lock. She's not allowed to do that. She booted them out with the help of an off-duty, paid-for-hire Atlanta Police Department officer. And the only thing she used was the letter that Mr. Williams gave. Mr. Williams is a fine counsel, a well-learned attorney. He knows very well that without a court order, you cannot effectuate an eviction. And there is no such thing as a self-help eviction under Georgia law, as well as the fact that my clients had every right to deduct and repair under well-settled Georgia law. And they brought these issues and they still paid the rent. And as Mr. Wesley pointed out, there was a pattern that had been established, a relationship that had been established between them and Ms. Embry. And even though these last few months may have been difficult, they had otherwise demonstrated a huge amount of success over the last 2.5, almost 2.5 years since they had been in the space. But the portion of the space, Your Honor, I think there are two things to look at. One, this should have never happened. Ms. Embry had no right to evict them without going through the proper process, and a letter from an attorney just simply was not sufficient. But also, Your Honor, the goodwill that they created at that particular space, their ability to fulfill their orders, that space was required for them. To accomplish that, they had put creative energy into designing the space so that customers could come in. So they had put a lot of energy and creativity, there cannot be any adequate remedy at law, Your Honor, for getting back the creativity that they put into that space and able to invite clients, to win over clients. No, not to mention, Judge, what they lose each and every day. You can't calculate what it is to have someone, for a designer, what it is to have someone put your dress on and wear it on a talk show or wear it on a red carpet. They're not able to fulfill orders from certain celebrities right now. Those things are incalculable in terms of what it means to the growth of their brand, their business, and their creativity and ability to thrive. You know, what was taken from them was over 400 creative designs, blueprints, artwork, all sorts of things that they don't get back. And it's not just getting that back. You know, sure, you can get it back, but if you don't have the space to actually do the work, then you lose your ability to still do what they would do, which is fulfill these orders of clients. And I think based on that, Your Honor, we meet the elements of an injunction. As Your Honor well knows, you have broad discretion to grant this type of equitable relief as the litigation pins, and that won't be disturbed unless there's been a demonstrated abuse of discretion. But I think in this case, Your Honor, there is a uniqueness to what my clients created in that particular space, the goodwill they've built and the goodwill that they lose every single day that they're not able to fulfill various orders and continue to compete in this very competitive industry. Every day that they're not able to work from that space to create and to do what they love to do, there is a day that they just simply can't get back and may never get back, Your Honor, if they're not able to go back. You know, in the fashion design world, every season comes, you know, spring, fall, summer. Every time they're losing the ability to create for the fall, which they are right now, they're losing out to competitors. And you just can't get that time back. And I think that that's what's most critical here, Your Honor. In addition to the fact that there really was, you know, this was in fact an illegal eviction. And I know Your Honor will be the one who decides that, but I think it's pretty well settled under Georgia law that you cannot evict someone the way in which Ms. Embry and Mr. Williams attempted to do so in this case.
So are your clients in a position to remain current on rent?
They are, Your Honor.
Okay. All right. Well, let me hear from Mr. Williams.
Thank you.
And let's start, please, with a response to the assertion that there is no self-help eviction in Georgia.
I would start there. As an initial matter, Your Honor, we will request to tender into evidence defendant exhibit 1, 2, 3, and 4. Those were the 4 that we submitted.
I will, and Mr. Sterling, I think it was just one exhibit, that video. I'll make that part of the record as well. If there were other exhibits you did put up, I'm not excluding them. I'm just not remembering if it was anything beyond the video.
It was just that one, Your Honor.
Okay.
Thank you, Your Honor. Mr. Sterling has been a friend of mine and a colleague of mine for a long time, and it's good to at least see him on the screen, and he's just flat out wrong. There is self-help allowed in commercial leases such as this. Residential leases all day long. I 100% agree with him, and that's what case law says. That's what statutory law says. The dispositive case on this is Rucker versus Wynn, W-Y-N-N, 212 Georgia Court of Appeals 69. This remains good law. This remains the definitive law on this subject. And I quote, "A landlord may contract to avoid the statutory notice of other requirements of dispossessory proceedings set forth in OCGA section 44-7-50 when renting property which is not to be used as a dwelling place." That case goes on to say, where under the terms of a commercial lease, a landlord has the right to re-enter and take possession of the premises without recourse to legal proceedings, the landlord may do so and effect a, quote, self-help eviction if this can be accomplished without a breach of peace. That's the standard. Under that law, we had almost identical language used in their commercial lease and ours, that we had the right upon an event of default, without notice, without opportunity to cure, to undertake a number of options: retaking possession, rekeying it, changing the locks, retaking possession, and not even terminating the lease. Our lease, just like the lease in Rucker versus Wynn, did not require notice or an opportunity to cure, but we did that here. We tried.
Well, you tried. It
We
sounds
tried.
like there was some confusion about who was representing the tenants. You were following the channel that was presented to you because Mr. Burrows reached out to you, and you were correctly not reaching out to his clients.
Correct.
Because he, Burrows, had represented himself as counsel for Mr. Wesley.
And he did so more than just that one email, Your Honor. There were voicemails traded. There were additional emails traded. There are emails in the assembly of defendants exhibit number 2, where in direct communications with my client, the plaintiffs said, "You were here from the attorney." There was never any, believe me, if Mr. Sterling had been involved from day one, I'm sure we would not be sitting here today. We would have a different result. That's not where we are. The lease here that is into evidence that was negotiated freely and intentionally provides self-help, provides the mechanism that was exercised after repeated opportunities to fix this. And we've talked a lot about those two. I'm sorry, Your Honor, go ahead.
Well, just I want to make sure we're able to flesh this out and Mr. Sterling gets a chance to respond. What about returning the property? That's where I started with Mr. Sterling, having a similar understanding as you as to the significance of a commercial lease versus a residential lease and the prohibition against self-help in one and maybe not in the other. What would the basis be for your clients to continue to possess all of the property that Mr. Woodard and Mr. Wesley had on the premises before?
The lease did not require us to maintain that. The lease gave us the opportunity to move everything out and put it to the curb. We are not in possession of any of the remaining personal property. That was repeatedly offered to him to come remove it. We're not under an obligation under either the lease or Georgia law to pay to store that. while he thinks about coming to get it.
So there's nothing to
there's
return.
nothing to return, which
Okay.
gets me back to what we are here today on, not the underlying merits of this commercial lease dispute. You know, maybe we didn't do it correctly. Maybe Mr. Sterling can beat me. That is it for a different day. What we are here on today is this TRO. And the TRO is to preserve the status quo. And the status quo here is that they're not in possession of the property. They're asking this court to return them to possession of the property. They're not in possession of anything that may have been in that space. And they're asking this court to return that. That's not the standard. The threat of irreparable harm, the threat of damage, the threat is over. The action has occurred. And Mr. Sterling has sued my clients alleging compensatory damages, punitive damages. There is an adequate remedy of law here if we did not follow the terms of the lease, did not follow Rucker, and did not do our duty to this tenant that we were supposed to.
So to recap what I think you just said, the only relief that I could provide plaintiffs at this point through the TRO would be to return them to the property, not return their property, if that makes sense. In other words, I may be wrong in doing it, but I could say, you know what, Mr. Wesley and Mr. Woodard need to be back in 2291 Cascade Road. I'm confident you would comply. There might be an appeal, but you'd comply, but they go back to an empty building and there wouldn't be materials, sketches, et cetera, that would then be brought to them in that space.
That's correct, Your Honor.
Giving them their atelier, as they said.
That's correct. And the lease nor Georgia law requires us to keep that space open for them after a termination, after self-help, after we lock the locks.
Okay. All right, Mr. Sterling, I don't know if you just learned something from that exchange. I did, in terms of what my ability would be to say, please give Mr. Wesley and Mr. Woodard their merchandise, their inventory back. I think we're now down to what to do with 2291. In other words, the lease, as opposed to what may have been on the property at the time that the eviction was affected. What do you want to say, if anything, in response to Mr. Williams's argument? You're on mute.
Your Honor, I would say regardless of Mr. Williams' assertion and even the case law, I would say the eviction was still unlawful because Mr. Williams, even without my clients being aware of what was communicated to their previous attorney, still came into compliance with what was requested of them, which was to come up to date with the actual payments that were due. So if you look at that letter that my clients never received, that was on April 11th, they came into compliance on April the 15th, I believe was Mr. Wesley's testimony. And then a few days later came into compliance on the remaining amount for April's rent, even as they tried to get the landlord to do what they were required to do under section 2.5 and 6.1, which was to fix the plumbing issue. And as Your Honor pointed out, when they accepted the property as is, it was Ms. Embry who entered the property and changed things, and then they just asked her to request it. So they were allowed to obviously deduct and repair. And so even as they experienced these issues, now, Your Honor, it is terribly, terribly upsetting, and I'm sure it's news to my clients, that nearly 20 years of work was destroyed by Ms. Embry of their hard, creative design. And I know there's nothing the court can do about it now, and obviously we'll have the litigation, and I certainly intend to litigate on behalf of my clients what they lost by what I still consider to be an unlawful eviction. But they came into compliance as per Mr. Williams' letter, even if the difference between, even if my argument doesn't hold, Your Honor, that this wasn't a lawful eviction because they didn't go through the court process, I still think the eviction was unlawful because my clients did, as indicated, they came into compliance with what was requested of them, which was to come current with their rent payments. They did that. But, Your Honor, it really seems like this was, that there were no issues until Mr. Wesley, as Your Honor could see, there were no issues with the landlord until Mr. Wesley brought these concerns to their attention. And so then all of a sudden it was, well, we've got to hurry up and evict you. But I would say, Your Honor, I don't know. I don't know if my clients would still, without their creativity and designs, I don't know if they would still want the injunctive relief we've requested. But to the extent the court can provide and has discretion to provide some injunctive relief, we're not going to be able to preserve the status quo at this point because, it sounds like based on Mr. Williams' representation that his client has destroyed nearly 20 years of my client's creative work.
So why don't we do this? I think that, Mr. Sterling, you're going to need a few minutes with your clients, given some of what we've learned today. Why don't you confer with them? And then if you would send an email to Ms. Niles and to Mr. Williams, letting me know if, despite what we've learned, your clients want to seek the relief of being returned to 2291 Cascade, where they'd have to pay rent because they wouldn't be there rent free, given everything else we've learned. And if the answer is yes, then I do need to rule on your motion, and I will. It doesn't mean I'm granting it by asking you that, but no one needs to spend more of your client's time or yours that your clients pay for, Mr. Williams' time or what his clients are paying for, if, given what we've learned, your clients want nothing more to do other than this lawsuit with 2291. But if they do want to get back in there, I just need you to reaffirm that in an email to Ms. Niles and Mr. Williams. And ideally, you could have some time with them today and just send that email today, and I'll jump on this. I don't want this to delay. It is urgent. And I want to get closure to this introductory chapter to this case. I think next will be an answer. We'll have a scheduling teleconference, figure out what we're doing next with the case. But I certainly want to pay the attention that is due this important issue. It just is now different than I was thinking, because as you know, when I first stopped you, Mr. Schilling, I said, well, why don't we get your clients their stuff back? That's where the genius is. It's a nice building, and I appreciate they invested and injected creative energy into the building. But in the end, 4 walls and a roof with Mr. Woodard underneath it and Mr. Wesley helping market and do all the things he does, they are creating what they can create. And there was some magic to 2291. Sounds like that may have been dispelled to a certain extent. And I want to help them move forward as best I can, consistent with the law. So have that conversation with them, please. Get back to Ms. Niles and Mr. Williams. And either I can deny the TRO as moot because you're saying, you know what, we don't want to get back in there. We don't want to be paying rent for that space anymore. It's cursed. Or you'll say, yes, they want to be back in there. They're going to rebuild and press forward. And then I'll need to enter a ruling on the TRO, whatever that's going to be. And I commit to doing that in fairly short order.
Yes, Your Honor. I'll do that, Judge. Thank you.
Okay. Anything else, Mr. Sterling, from your side?
Nothing further, Your Honor.
All right. Mr. Williams, anything else on behalf of your clients?
No, Your Honor.
I want to thank both sides for participating. Mr. Wesley, I'm sorry that we had a choppy connection for you and Mr. Woodard. Sorry, we never got to hear you. Hopefully you feel like Mr. Wesley represented you well. He spoke, I think, very passionately about what you do and your work and how for 20 years it's what you've been. He says you wake up and there you are creating and designing. And I wish you only more of that, whether it's at 2291 or somewhere else. I will continue to work with these lawyers as we navigate this. As Mr. Sterling has pointed out, regardless of what happens today, there's much more to be said and done. He's brought a number of claims on behalf of both of you, and he will continue to pursue those claims. Ms. Embry and Mr. Flournoy, it's nice meeting you. You didn't have much to say today, but that's all right. Your lawyer did the talking. And hopefully, second-year law student, this was an interesting experience. They didn't let you say anything at all, but I'm sure you were channeling legal energy that way. I'll let you all go. Mr. Sterling, we'll look for your email, and that'll guide me as to what I need to do next.